My name
Okay.
is Larry Taylor, and I'll be moderating today's Police Misconduct and Qualified Immunity Reimagining We the People. Before we begin, I would just like to thank a few of our sponsors, the American Association for Justice, the Robert L. Habish Endowment for sponsoring Police Misconduct and Qualified Immunity Reimagining We the People. I would also like to thank the members of the Planning Committee and recognize Dean of Texas Southern University, Thurgood Marshall School of Law, Joanne R.M. Bullock, the Executive Director of the Earl Call Institute for Legal and Social Policy, Sarah Guidry, and Dr. Howard Henderson with the Texas Southern University Center for Justice and Research. If you have any questions, if you're an attorney and have any questions about American Association for Justice, visit us at www.justice.org. At this time, Brittany, let's move forward and have Howard and his panelists start. Thank you. Howard.
Okay, perfect. Good morning, and we welcome everyone to this first panel. We're so excited to have conversation and have our guests with us this morning. Let me do a brief introduction so we can get into this conversation. This morning, we have attorney Joanna Schwartz with us from UCLA. Attorney Schwartz is one of the legal experts that we came across when we were doing research in this space. We're so elated to have her to be a part of this conversation, and we will be glad to know what she's able to bring to the table in terms of understanding qualified immunity in the George Floyd Act as we have in Texas. We also have April Fraser Kamara, who has become to be a great colleague of mine, who we now understand we have a lot in common. We are from the very same state of Tennessee, but we also know that she's a great legal mind, and we're glad to have her here representing Washington, D.C. and her group. And so, April, we're so glad to have you here. We look forward to having the conversation, and we know that you're going to add a lot to what we bring to the table today. We also have Chris Colbert, who is an expert in his own right, and he will be able to explain his experience in interviewing individuals who have been family members of victims in terms of leading with qualified immunity and police abuse as we see them. Now, let's kick this off with a conversation. Joanna, we have had plenty of previous conversations about qualified immunity and what that means. Can you tell us, in your own words, what does qualified immunity mean? But also, what are some of the most pressing challenges when dealing with qualified immunity around the country?
Great, thank you. And thank you so much for having me here. It's an honor to be part of this conversation. So qualified immunity is a defense that law enforcement officers and other government officials can raise when they are sued for money damages in a civil rights suit. So if a person brings a case, they say that their constitutional rights have been violated. A police officer or other government official can raise the defense of qualified immunity that says the case against me should be dismissed, not because I didn't violate the Constitution, but because the right that I violated was not clearly established. And what the definition of clearly established has changed over the years. This is a doctrine that was created by the Supreme Court, and they have repeatedly issued decisions that make it harder and harder to achieve this goal. But today, if you read the Supreme Court's decisions, the message that they are clearly sending is that in order for a right to be clearly established, so for a person to get past the qualified immunity defense, they have to find a prior court decision from that court system that they're part of, that court of appeals, that held unconstitutional virtually identical conduct. And if they can't find that case, if a police officer has violated someone's rights in a way that hasn't been done before, in precisely that way, then the officer case can be dismissed from suit. And if you the cases you will see have require very, very, very similar facts. So there is a case in which a person was suspected of a burglary. He sat down, raised his hands in the air, and surrendered. And the police still released their dog on him, who bit him and maimed him. This person brought a lawsuit, and the officers said qualified immunity. And There was a prior case where police dogs had been released on someone who had surrendered lying down. And the court said, and in that case, the court had said that that was unconstitutional. That was excessive force. The court, considering the case of the man who had the dog released on him while he was sitting with his hands up, said the factual differences between someone lying on the ground and someone sitting with their hands in the air is enough to mean that the law was not clearly established. And the Supreme Court has made it even harder to get over this hurdle because they have told courts that they can grant qualified immunity without ruling on whether the law, whether the officer's conduct was unconstitutional. So on the one hand, they're telling plaintiffs, you have to find a prior case with virtually identical facts. And on the other hand, they're telling courts, you don't have to decide whether the Constitution was violated. Qualified immunity is also, I'll tell you two more things and then I'll stop, but there's a lot of things wrong with qualified immunity.
Yeah, please go on, tell us.
The officer's intent doesn't matter to the analysis. The officer can intentionally have violated the law, knowing that what they were doing was wrong. But if there's not a prior court decision, it doesn't matter. Final thing, the standard requiring a prior court decision with virtually identical facts is justified by the Supreme Court on the idea that officers need notice that what they're doing is wrong. But I've done research that reveals that officers are never educated about these cases. They're not told about the facts and underlying circumstances of every single court decision. They would never have the time to do that in their training. And so this whole idea that we need a prior court decision has no basis in how officers are actually trained. The qualified immunity defense is justified as a protection for officers because they need financial protection from liability. But I've done research that shows that officers virtually never pay anything in settlements and judgments entered against them. So the whole justification for this defense that is so harmful for people whose rights have been violated isn't even needed under the justification that defenders of the doctrine offer for it. So those are some of the problems with qualified immunity.
Thanks so much. April, I want to get you in this conversation, Attorney April Frazier-Kamara. And again, I didn't want to spend a lot of time on the front end introducing everyone, but I want to get into the conversation. But you are an expert and a force to be reckoned with because you bring together some unique pieces to this conversation. And one is in your position as the director of the Black Public Defender Association associated with the National Legal Aid and Defender Program. Talk to me about how you see all of this in terms of dealing with police officers, dealing with qualified immunity, and speak to me about the impact of qualified immunity on the role of a public defender and how you think it impacts the criminal justice system, particularly for the indigent.
Well, first of all, thank you, Professor Henderson, for inviting me here today and organizing this amazing symposium today to talk about this important issue. So, as you said, I'm the co-founder of the Black Public Defender Association. And one critical piece that we realized that was missing, even in the public defender community, is really an analysis of race and the criminal legal system. And so for Black defenders, we understand both professionally and personally how this impacts our communities, and also the history of qualified immunity and really being used as a tool to justify the terrorism in our community by law enforcement. So I think one missing component oftentimes when we do the legal analysis is really exploring historically how this tool has been used to justify legal justification of terrorism inflicted upon the Black community by law enforcement. And thus, there is no legal recourse for the Black community. So I think people have to understand when we look at what is the origin of these doctrines, why have they been so narrowly tailored and interpreted by the Supreme Court, you cannot divorce that analysis from a analysis of American history and the horrors of white supremacy in this country. And that's what our conversations around policy reform as Black defenders bring together, that history of racism and the horrors of the criminal legal system. So just to talk a little bit about what does it mean for people who are indigent. So many of you know 80% of people who come in contact with the criminal legal system are represented by public defenders. They cannot afford counsel. And so for the clients that I represented, the qualified immunity doctrine and how that plays out, oftentimes as public defenders, we see daily ordinary injustices that law enforcement and oftentimes prosecutors, they turn a blind eye to. The client who we meet in lockup who has the black eye, the person who complains about, the female client who complains about an officer touching her inappropriately. And so unless you get to the level of abuse and harm in cases like George Floyd, very rarely do you hear about those daily injustices that take place, and really truly is a part of the culture of many law enforcement communities, but also a culture of the system that allows people to be harmed and there be no consequences. And so, for public defenders, we hear daily from our clients about, I talk about what does it take for an officer like Derek Chauvin to have the courage to publicly lynch someone on a busy street in daylight, right? It took a number of ordinary daily abuses and injustices that was never addressed. And oftentimes public defenders may have raised those issues in court. They may have had their clients file complaints with the Citizen Complaint Review Board, and those calls are oftentimes ignored. And so that's where we get to the level of abuse that makes the news, because we allow for those daily injustices that happen every day. We may pass by a traffic stop where we see someone being abused, their rights being violated, and those daily abuses are never addressed. And then we get to a national awakening because you publicly lynch someone in public. So I just want to really talk about how important for us to tie this legal analysis to the history of racism and white supremacy in this country. And we also have to talk about how the American legal system has they have legalized a lot of the abuse. And so it's time for us to challenge, similar to Brown v. Board of Education, just because it's, quote, legal, it does not mean that it's just or equitable.
You've given us so much, April. Professor Schwartz, I wish I could take notes on what you both have given us. Unfortunately, I have to moderate this panel, and hopefully my students are taking copious notes from me because I want to digest those. But Chris, you bring a unique perspective to this conversation. When we look at your background and when we understand where you're coming from, man, you have done some great work in making sure that people get this story in mainstream America. When we look at the projects that you've worked on around the country, the people you've worked with, but one in particular, when we talk about your project telling the story, and when we understand what it means to understand the experiences of being victimized by the police in this country. When we understand that, can you help us bring this down to a level where you've talked to the families of these victims? What can we learn from what you learned through interviewing these individuals around the country?
Yeah, thank you. And I'm very much humbled by being on this stage with all these great thought leaders and the great work that you all are doing. We worked on a project called Say Their Name, a podcast series where we were going around the country talking to families about their loved ones who have been killed or assaulted by police and in stand your ground states. And as you were setting up there, it is important that we hear directly from these families because we don't often hear from them. And if we do, they tend to be in sound bites and, clickbait type of things that are meant to get your attention. So, these narratives tend to be controlled by the media and by the police. And so we wanted to hand this platform over to the families to give their perspective because, let's just assume that, the media is doing nothing nefarious, but they still tend to take the police's side in terms of what the story is. They will run with that immediately. And part of that is because of the media service, it's all about being the first out. And so a lot of times they don't have time to fact check things and they're just taking the police at their word, which many times is incorrect, as we found out as we talk to these families. And that's where it's important to talk to them to get their perspective and get their understanding, not only just of what happened, but then their journey for justice. And that's where it kind of plays into this qualified immunity conversation, where these families are victimized, first of all, when they lose their loved one or their loved one is assaulted. But then you have that re-victimization that happens as you go through the court system and they delay the process to be able to get restitution. Obviously now with COVID, you have other delays that are beyond their regular delay tactics. Now you actually have a pandemic on top of that. But that costs money, that costs emotional and mental strain on these families on top of what they're already experiencing. And then when you then look at qualified immunity, now you are up against a unwinnable foe. As was touched on by Professor Schwartz earlier, you have to prove now what the intent was, or what the officer was feeling. How do you disprove what the officer is feeling if they're telling you that they felt scared for their life? So one case in particular that I wanted to mention here is that of Robbie Tolan in Bel Air, Texas, just outside of Houston. He was shot back in 2008, I believe. And he did live to tell his own story. And I say it's kind of fortunate that he lived to tell his story, but let's not also forget that he has to live every single day with the physical and emotional scars of what he experienced. So, let's not look at him as some great success story. He is living this every single day. But at the same time, his family was actually able to fight all the way to the Supreme Court and win a case on qualified immunity. But that took them years. That took them almost 8 years to be able to fight and get that case heard and won in the Supreme Court. And to do so, they had to sell their home. This is a family where the father was a Major League Baseball player, almost a Hall of Fame baseball player on top of that. The son, Robbie Tolan, the one who was shot, was actually drafted to the Washington Nationals and was in his first year of climbing up that system. And his career was taken away from him from being shot. And a family that is that well off still had to sell their home to be able to fight against qualified immunity. So that shows you how difficult it is and the strain that it takes on a family, just from a financial standpoint right there. But let's also remember too, that they had a home to sell. Not all families have a home to sell. They don't have those means to be able to try to get money. And they also had favors from lawyers who were giving them, pro bono work and things like that. So that's not to throw the blame at the lawyers here. They also have to get paid to make a living too. But at the same time, the system is set up for failure for many of our communities. And I'm just going to recount one thing that a family member told us when they were in the courts, and the judge said to the jurors, they said, if you think that the officer may have feared for their life, you must acquit. And like, if that is what we're up against, we can't win. And just to mention one more thing with them winning the Supreme Court case, that case within its first, I believe, 5 months or 6 months, was cited in helping over 500 court cases just within that first 5 months. But that being said, we're still facing qualified immunity as an issue. So even though that is a precedent, it's not being applied at a great enough rate and at a great enough kind of scale to be able to actually help in the way that we need to. So we actually need to change laws. We can't just have a precedent. We actually have to change laws.
Oh, wow. Chris, I really appreciate that because you provided us some context to this. Joanna, let me ask you a question. And you put out an interesting article in 2018, the case against qualified immunity. And you articulated those places and the chinks in the armor of qualified immunity, per se. We are in the Fifth Circuit right now. Well, I am. And we understand what that means for qualified immunity. And you articulated the places where qualified immunity received greater levels of support from the courts. Can you speak to that? What does that mean for us to be in these uniquely draconian areas of the country where qualified immunity seems to be a lot stronger than others? And what I mean by that, can you speak to, how qualified immunity looks different in circuits like the Fifth Circuit?
Yes, thank you for that question, and I really appreciate that Chris mentioned Robbie Tolan as well, a case out of the Fifth Circuit, out of the Northern District of Texas. I've looked at qualified immunity cases around the country. Texas, with no disrespect for your state, Texas is the worst when it comes to qualified immunity. And the Fifth Circuit, which is the Court of Appeals that hears cases from that come out of Texas, is the worst Court of Appeals. You have a really, really hard road to climb when it comes to qualified immunity. The courts are the judges who hear qualified immunity. One thing they do is they've created, the courts have created their own rule, which the Supreme Court has never said is the right rule, which is that if a defendant argues qualified immunity or raises qualified immunity, that puts heightened pleading requirements on the plaintiff at the beginning, meaning the plaintiff has to come forward with additional facts to show exactly what happened in the case that can defeat qualified immunity. And then Texas law doesn't require law enforcement agencies to turn over any information related to these cases, so long as it's part of an ongoing investigation. So there's a pressure on either side. The law says that the police do not have to turn over any information. The court says you have to give us detailed information about what happened before you can go forward. There's a case brought by a man, or by the family of a man named Tony Timpa out of Dallas. He was killed beneath the knee of two police officers who put their weight on him while he was handcuffed and zip tied his feet, held him down for 14 minutes until he died. And that was a case in which the family couldn't know anything about what happened because he had passed away. Unlike, Robbie Tolan, whose family was around him, Tony Timpa had no family and he was no longer there to tell his story. There was video footage from body cam video that the city of Dallas refused to turn over because there was an ongoing investigation. And so the lawyer and the family had to file a complaint with bare bones information that they were able to glean from the police incident report. And then the city tried to get the case dismissed because the complaint didn't have enough information, even though the city was holding the information and refused to turn it over. That's a rule specific to Texas. Although other states have things like that as well. And it impacts the difficulty in state law, the difficulty of qualified immunity, the judges who are very sympathetic to qualified immunity has a further effect, which is that lawyers are reluctant to bring these cases because, as Chris said, lawyers have to keep the lights on, and lawyers try to bring these cases, invest sometimes tens of thousands of dollars of their own money, because lawyers in these cases do not get paid unless their client wins, and then they get a portion. So they invest $10,000, $20,000, $30,000 of their own money. The case gets dismissed, and the lawyer thinks, you know what? I'm going to go back to my personal injury cases. I'm going to go back to my medical malpractice cases. This stuff is too hard. I looked at lawsuit filings in the city of Houston for a 2-year period. In a city with thousands of police officers and millions of people, in 2 years, I found 25 cases alleging police misconduct. In Philadelphia, a city of comparable size, there were 10 times as many lawsuits. In Houston, during that 2-year period, there were 5 cases where a plaintiff recovered anything in those suits. In 4 of the 5, someone had died. In the 5th, deadly force was used, and they managed not to perish. In Philadelphia, 10 times as many verdicts and awards, and 100 times more awarded to plaintiffs in these cases. In the city of Houston, there was not a single person in that 2-year period who ever recovered anything for false arrest, wrongful searches, for anything that didn't include force. And that's partially because of qualified immunity, but it's also all the downstream effects. The fact that lawyers are concerned about bringing these cases. And so there is not a functioning system of civil rights enforcement, in my view, right now in the state of Texas, because of Texas state law combined with qualified immunity.
And I appreciate that, particularly when you contextualized it to Texas and Houston and understanding what it looks like in relation to the national landscape. Attorney Frazier-Camara, let me ask you a question, because one of the points that I didn't bring up was the fact that you are, and I'm not sure how much longer you will be, I don't know the term, but you are the chair of the American Bar Association Criminal Justice Section, okay? Let me ask you a question. Can criminal justice reform actualize without adequately addressing qualified immunity?
I think the answer is no. Professor Swartz brought up a really good point about enforcement. We continue it's a myriad of issues of accountability. And so much focus is on police misconduct, but as someone who have clients who are kept in cages, I'm concerned about prison conditions and how people are dehumanized in general in the criminal legal system. And so the enforcement tool, the relief under Section 1983 has been stripped. Prison rights advocates have not been able to enforce humane conditions for people who are incarcerated. So this is really whether or not we are going to allow for the enforcement of civil and human rights within, and whether or not we're going to have a humane criminal legal system. And so, no, I don't think we can talk about comprehensive criminal legal system reform without talking about qualified immunity. And we also, when she shared the numbers about Houston, we have to talk about how that plays into the culture within the Black community. If you live somewhere where you see rapid police misconduct and there's never accountability, no one ever wins, and then you want us to have faith in the same system when you say, oh, come to us with your problems and we can, so the integrity of the criminal legal system is tied to whether or not there is enforcement as well. So even, I'm a fan of, we really need to dismantle the criminal legal system and rebuild again a much smaller and humane system. But for those who have faith in the existing system, you should be concerned, because how do you expect communities to have faith in a system that never protects them and they never win and they never feel like people who are bad actors are being held responsible?
So let me ask you this question, Chris. Piggybacking off what Attorney Frazier-Camara has laid out there and the defund the police conversation and the role of all of that in qualified immunity being one of those spaces where we need a lot of change. From a person who is well-versed in media messaging, what role does the media's message play in our approach to qualified immunity in terms of educating the public, in terms of understanding how we may go about making change? Because we've seen what social media has been able to do over the last few years in terms of galvanizing people, particularly young people, around a common message and fighting for social justice in these spaces. Can you speak to how you may suggest that media utilize its best practices to help reform criminal justice system, and most notably, in our case, qualified immunity?
Yeah, I think, media plays a very large part in all of this. As we kind of touched on before, they're the ones that control the narrative. And depending on who they are getting their information from is how then the public will interpret these situations. So I think just from that standpoint alone and how they are who they are deciding is giving them the correct facts, how they're giving fair balance to the actual families. I see very few times that the families are truly given a platform. And part of that, again, is like we do these quick news stories that only are a minute to 5 minutes long. You can't capsulate what has happened in that amount of time. So I think we need to take a new look at how we do our media coverage, or at least as citizens that have better understanding of, okay, this is just introducing me to this story. I have to dig deeper somewhere else to get that. And that's where I implore other media companies to do what we have done in terms of handing over our platform to the families and their advocates to talk about their perspective. In terms of how it then plays into qualified immunity and how we can educate, again, I think it's talking directly to the lawyers, talking directly to the families about their experiences. For instance, with Marquita Thomas, who's also in the Houston area. Her brother, Danny Ray Thomas, was killed, I believe, in 2018. He was having a manic episode in the middle of the street, pants around his ankles, hands at his side. So there's no way he could have had any weapon. He was having a mental health struggle that was all predicated on his children being killed by his wife a few months earlier. And instead of responding with somebody who could come give him mental health care, they sent an officer who, within seconds of coming out of his car, shot and killed him. And Marquita, as she is trying to fight and get some kind of restitution, the prosecutors would come to her and get information. None of the information that she gave was presented in court. None of it, including information where she gave that the officer had actually threatened her brother months earlier and said that I am going to one day catch you and shoot you in the back. Now, he didn't shoot him in the back when he killed him. He shot him in his front. But at the same time, there was a threat before, and that threat was never brought up in the court case. And I think that kind of information is what the public needs to hear and understand, to understand that this system is rigged and it's set up in a way that is not going to get restitution for these families. So I think that's where the media can come into play to feel like we have to, and I am saying that for a specific reason, we have to hand our platforms over to these families and their advocates to be able to give us, that other side of the story, or from my perspective, the real story.
So, Joanna, we're going to close out shortly because I want to make sure we respect our time, but this conversation is so powerful. You lay out what you see as a prescription to change this situation, okay? And you identify certain factors that you think need to be in place to make it happen. But you also talk in one of your articles, you talk about police training and what they're trained to do and what they're not trained to do, and how much time they have and how that impacts how they interpret, particularly Graham versus Connor, okay? If we are going to change qualified immunity in this country, what are those key elements that need to be in place, and how do we get there?
Well, it's a big question. I think that my point of view is that we need to end qualified immunity. Officers do not need qualified immunity. And part of the reason for that is that there are so many other protections that are already in place for law enforcement. As I mentioned before, and connected to your question, defenders of qualified immunity say we need the defense so that officers acting in good faith aren't bankrupted for split-second mistakes that they make. But all of the evidence shows that officers almost never pay anything in these cases. There's no danger of bankruptcy there. And the Fourth Amendment, as interpreted by the Supreme Court in the Graham versus Connor case, which is the bedrock for police training, and the Fourth Amendment, says that officers can make reasonable mistakes. They can shoot the wrong person, search the wrong person, arrest the wrong person, as long as the mistake was reasonable. So part of that, why I mentioned that, because those decisions, those mistakes are still going to be protected by the Fourth Amendment, even if qualified immunity goes away. Now, there's a separate conversation that if we were to get rid of qualified immunity, should the Fourth Amendment be in the structure that it is, gives so much discretion, so much leeway to government decisions. I personally don't think it should, but that's a second set of conversations. If qualified immunity goes away, it means that the cost and burdens and complications of litigating these cases are going to get lower. It means that more lawyers will probably be willing to take these cases. It means that when these cases are filed, the focus is going to be on what the officers did, whether they violated the Constitution, not whether someone can find in doing their legal research a prior court decision. So the focus will be on what the officers actually did. And I think that that's really important. There's going to be more decisions that are issued by courts that explain what the Constitution requires. Right now, there's a lot of decisions that grant qualified immunity, but don't explain whether the law was violated. And to the extent that police departments want to train their officers about the law, qualified immunity makes it harder to even understand what the law is. So there's a lot of important things that ending qualified immunity will do, but it is not a cure-all. Ending qualified immunity, connected to Ms. Frazier-Camara's comments in the beginning, ending qualified immunity is a very important piece of the puzzle. And qualified immunity is a manifestation of racism in the criminal justice system and abuse of power in the system. But ending qualified immunity on its own is not going to be, is not going to end all of those things. There is still that backdrop. It's, to my mind, the most important first step that a state legislature or Congress or the Supreme Court could do. But there is a lot more to be done in training, in the way in which we think about what police role is in our society and how we think about investigating and supervising the officers that we do have and more. So it's one piece, but it's an important piece.
Attorney Frazier-Camara, and we'll do this last round that Professor Schwartz started off. What's step number 2? Where do we go from here? Because oftentimes we have panel discussions and we kind of pontificate about a problem, but you're very solution oriented. Mm-hmm. And, I've watched the work that you all do, and you focus on addressing problems with solutions that make a difference, and they're racially equitable. Okay. And the recent piece we put out on saving Black lives together as a collaborative effort, we talked about the fact that race neutrality doesn't necessarily exist. Okay. From your perspective, what's step 2B?
I think we have to have a very serious conversation in America about reparations. We have to do something to right the wrongs of the past. And when we talk about all of the cases, all of the harm that has been done to Black and Brown communities, unresourced communities, under these laws, it's one thing to repeal or change qualified immunity, but what happens to Marquita? My family, my uncle died in jail. And, fortunately, we got a settlement. But what do you do to repair the harm that you have done for centuries to Brown and Black communities legally through the defense of qualified immunity? And reparations has to be a part of the conversation. And let me just say this about where we are as a country. There is a need for us to focus on unity and how do we move forward, but you cannot unify a country until you confront and address the harm that has been done. And that's why we have to talk about reparations. And we have to talk about how do we offer restitution to people who have been harmed by the system.
No, and I think that's a good point, and one that we are oftentimes afraid to have conversations about. Chris, and I'll give you the final word before we close out. We're on the campus that has a historical law school, Thurgood Marshall School of Law, and we have the Barbara Joy McLean School of Public Affairs, and we have a School of Communications, and we're located in the heart of Houston, Texas, in the belly of the Fifth Circuit. How can, from your perspective as a media person, what can be done to make sure we help this Fifth Circuit move in the right direction from the media standpoint?
Well, it has been said, I think all of this is just, there are a lot of steps, and there's not going to be a one size fit all for any of this. But I think accountability is something that is big in everything. And I know for me, as the grand scheme of things, I think that trying to set up a public database that allows us to see the records of police officers and their history, because as has been touched on before, these tend to be a pattern of escalation where officers see they can get away with things and then eventually someone dies, or they actually kill somebody and they do that over and over again. They may be moved around to different regions. So I think a public database will help us hold our public officials' feet to the fire around these things. It also can help us combat qualified immunity, I think, in some ways. I'm not a lawyer, so I don't know this for sure, but that can allow us to see, oh, this person has a pattern history. So you claiming that you feared for your life, well, there's a pattern that shows that you're going after specific people and harming them in different ways. So, that qualified immunity doesn't apply to you here because we see this pattern. Specific to, in that Houston area in the Fifth Circuit, and has been said, it is a situation that is rigged against, communities of color. I think from a media standpoint, we just have to tell these in-depth stories of these individuals. I hate to bring up the same thing again, but in terms of what the media can do, they have to make sure that they're giving an opportunity to, the lawyers like yourselves, like these families, to talk about what it is that they are up against and how they have been re-victimized in this process, so that the world can understand, okay, this is a specific area that needs addressing, and Houston in general, Houston specifically has such an issue that needs to be addressed.
Listen, Professor Swartz, Attorney Fraser Kamara, Chris Colbert, you have given us something to take with us and develop an action plan, which is very powerful. We understand that it's going to take unique conversations and it's going to take collaborative efforts from folks like you all. So we appreciate you. If you all have enjoyed this session, please say, hey, thank you so much. Let us know, because it makes the panelists feel good that they've come and shared great words. But I think these are the kind of conversations that we need to have. And please share your thoughts, your comments in the chat room. And we look forward to you being all day. And Mr. Sandman, Larry Taylor's here to get me quiet. Thank you so much.
Wait, Howard. Wait. I do appreciate you staying on time. Right now, we're going to open it up for some question and answers from the attendees to the panelists.
Thank you.
And as we're waiting for those to come in, let me say
Great
this.
Job, guys.
Thank you guys for being here. Everything that you said was directly on point. Professor, you are absolutely correct. Practicing civil rights in the state of Texas is a tremendous uphill battle. One of the things I like to mention also is qualified immunity doesn't necessarily just stay within the criminal law or a criminal activity. You also have activities that involve, like Breonna Taylor, someone who is a bystander of a criminal investigation or some kind of criminal activity, who is injured, but also is prohibited from getting justice because of this qualified immunity. The Texas Supreme Court has written an opinion that has basically shut the door on an opportunity for that type of justice to come forth. So I just wanted to make sure that I put that out there. And first question that we have is, what kind of pressure can we put on the City Hall officials to address these issues? I live in Dallas. We have a new police chief and are in a city and in a city council that is majority African-American. Great discussion. And I'll put that one, Howard, let's go ahead and get you involved. What do you think, my friend? Listen,
First of all, I'm a PhD in criminal justice. I would be foolish if I wanted to take a stab at that. But I will say this: I think the best thing to do is to link up with experts like Professor Attorney Fraser Kamara and Professor Swartz, but also Chris Colbert, man, because I think when you bring these pieces together, I think we need to be able to, number one, identify the problem. but also keep highlight on the individuals that are engaged in this process. Because people don't know, number one, who's on the city council. So they can't hold people accountable. They don't know who they are, right? And there's no light being shed on these people who are making critical decisions at a very local level. We tend to think about a lot of these issues from a federal standpoint, but the reality of it is 80% of our criminal justice system is a local issue. And I think we need to begin to look at it from that standpoint. But I'll open that up to the experts on the panel.
You know what? I have one that I think I'm going to tee up for Dr. Schwartz real quick.
Well, I think Attorney Fraser was going to jump on that one real quick if we can let her
grab
that one.
No, I was just going to say, being here historically at Texas Southern and as a graduate of Howard Law School, I think that's why it's so important, this movement lawyering, that as reforms are taking place, they have to, Dr. Henderson talked about the importance of collaboration, but the community should be driving what the solutions are and making sure you tap into the expertise of legal experts and media. But the reason why we have to be aligned with what the community see as the solution. So I think it's a great question. And I think for people who study these issues academically, public defenders, people who work in the system, you can't be moving these reforms if you're not in alignment with the community. So the power is in our communities, and the work that Chris is doing to elevate the voice. Even as public defenders, we should not be the voice. It's the voice of directly impacted people. And that's what our role is. So any effort should be driven by the community, and experts should only be coming in to advise, but not to lead the movement.
Thank you. Dr. Schwartz, someone asked that if you could define qualified immunity one more time.
Sure. So I know it's hard to understand, and it sort of makes your head spin when you actually hear it. So the Supreme Court created it, and it's changed over time. But what the Supreme Court has said is that officers have qualified immunity unless they violated clearly established law. And the way that they've defined clearly established law, they've said it can't be defined at a state of generality, like the standard for Graham versus Connor. It has to be specific, particularized to the facts before them. And so what it comes to mean in practice is that a plaintiff has to find a prior court decision where a court held that an officer acted unconstitutionally, and the way in which that officer acted is factually very similar to the case at hand.
Thank you, Professor. One of the attendees asked, and I'll go ahead and answer this one, how can we keep in contact or find more information out about the speakers? If you'll take a look on your screens, you can go down to the schedule, and at this particular event, there is a section where you can actually click on the speakers, and their information will pull up their bios, their emails, and any social media that they may have. So that information is available to you on the actual platform itself. So if you go back to the platform, you'll be able to get that information. Next question. And Chris, I'll throw this one at you. The police body cams, what kind of effect have they had on changing or addressing this issue?
I think all footage is good. It gives us more to work with, but unfortunately, we're seeing that is not making a full difference either. We're still up against the qualified immunity aspect of, did you fear for your life? And you can't see that on the video. Like, yes, we can, but in the court of law, we still cannot prove what is in someone's mind. So, the video doesn't show what is in someone's mind. So as much as those videos help, and we should continue to push to make sure we have those body cams, it's not always applied in a way that helps us against qualified immunity. That being said, we still need to push to make sure those are requirements for all officers. Not every police department is a requirement. Just looking at LA Police Department and LA Sheriff's Department have different requirements in terms of utilizing body cams. The Sheriff's Department doesn't have to, whereas the police department has a higher rate of having to use them. Also making sure that they're on at all times. I think we're seeing a lot now with some of these recent cases where we're seeing where the body cams are turned on after the shooting happens or after the assault happens. And yes, it's great that you get some of that back time. So, if I hit record now, it's going to show you some video from, I think it's like a minute leading up to that point, but you get no audio. You can't see what that verbal communication back and forth between the officer and the victim was. And so they can claim that they gave all these warnings, but there's no audio to support it. So we have to still set up systems and make sure they are used properly. Just to pivot just real quick, just to answer the last question I'd answered in terms of the media's responsibility. One other aspect that I didn't mention because we were really just focusing on qualified immunity is that it's the media's responsibility to also tell the story of these individuals. Like, who were they as human beings? I think we continue to look at them as hashtags and statistics, and that does a disservice to them and their families, because we hold police at such a high stature as the greater, U.S. public in general. And so when we see these victims who are killed, many times the media will run with a mugshot or run with some kind of football picture that vilifies them, makes them look more aggressive than maybe they really were. And the families, I know from talking to them, have not been consulted about what photo to use for their loved one. They've never been asked about, do they have a picture for them, or asked, who is this human being, so that they're not just seen as a statistic or as a villain if they were not. So that's the other piece for media, is that we need to tell the actual stories of these human beings and humanize and memorialize them so that we can get behind them and understand that they are humans just like, our brothers, our sisters, our mothers and fathers. So I just wanted to make sure I added that piece in as well.
And I'm going to try to leave us with some hope that things are actually moving forward. Professor, if you could you tell us of any success stories with legislation that is moving qualified immunity forward?
Yeah, absolutely. So there are states across the country that are introducing and considering bills that would create a right to sue under the state constitution without qualified immunity as a defense. Texas is considering that kind of bill right now, and I hope that it gets passed. In June of 2020, Colorado passed a really exciting statute. You could look it up. It's SB 217 in Colorado, and it creates a state law right to sue for violation of the state constitution with no qualified immunity as a defense. There's a couple of other things that it does that I think are really important parts of the process. One, that it provides for attorney's fees for people who bring these state law claims. Two, it requires that the city pay for the settlement and judgment in any case, unless the officer was convicted of a crime, which I disagree with that part, but I'll take it in general. And what the statute also says is that if a city finds that their officer has acted in bad faith, they will require the officer to pay up to $25,000 or 5% of the settlement or judgment, whichever is less. If they can't pay that amount, then the city will cover the rest. And I think that that's a really exciting portion as well. It creates some financial responsibility, some sanction for the officer, but it doesn't leave the person whose rights have been violated without compensation. To my mind, making sure that people whose rights have been violated get some form of compensation, which will never be enough to make them fully whole, but it's a really important first step. And so Colorado's statute, to me, is a model for us for the future. State law cause of action with no qualified immunity, attorney's fees, required indemnification, and a financial sanction for officers.
And Larry, I wanted to highlight New York City Council is actually considering a bill to create a reparations fund for victims of police misconduct. So a lot of great movement taking place at the local and state level. And I would tell people to be creative and not be wedded to a narrow fix. I think we have to be creative in figuring out strategies to not only correct behavior moving forward, but how do we restore people who have been wronged in the past?
And if I can just piggyback off of both of those, I don't know if everybody in the audience understands this, but when you see settlements that happen for these families, that money is coming from taxpayers' money. That's not coming from the police departments. That's not coming from the officer themselves. So as Professor Dr. Schwartz had mentioned before, it's great what Colorado is doing, because once you start hitting people in their pockets, that's when change begins to happen. So I just wanted to make sure people understood that right now you are paying to help these families.
Saying that, Howard, I'm going to turn it over to you to close out and take us to the next session.
Yeah, well, I'm going to close us out. I think great session. Larry, thanks for coming in and keeping us on track. We appreciate that. Again, Professor Schwartz, Attorney Fraser Kamara, Chris Colbert, we really appreciate you taking time out of your day, because I understand we all have COVID fatigue in places, but you made it here and our great audience is here. We really appreciate that again. And I think we're going to need to have more of these strategic conversations to make sure this happens. Now we'll proceed to the next session where we talk about the anatomy of 1983 litigation and Q&A session that begins at 10:15. Thank you all so much, and we look forward to you being here all day. Again, panelists, thank you so much for taking time and blessing us with your wisdom and knowledge.
Thanks for having us.
Thank you.
Thank you.